The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show. This is our 12th year of offering Ask the Experts in South Florida. And believe it or not, we still have many of the same experts that started off with us 12 years ago. Today's show is one of them. And it's my favorite show because first of all, it's very easy to do. But second of all 60 shows that we do each month, it is our number one show every month. Most listeners, most viewers, and we've just built up quite of an audience. If you'd like to call in today, you can call in at 561-623-9429. Today is our K. Bender Rimbaum show, Community Association Law. Hey, if you've ever had a question for an attorney about your HOA or condo association, you're going to get it for free today. So take advantage of it. Let me welcome you to my friend, our one-eyed friend, Robert K.
Hello, Steve. Hello, everybody.
Before we get started, we have to say happy birthday to Calvin, your grandson.
Yes, it is. Hey, 6 years old.
Wow.
Big boy.
Did you get him a car?
Yes, I actually did. It was a couple of years ago already.
Oh, okay. Well, you know what? We still get new people tuning in, finding the show. And so let's tell people, no one can do it better. Tell people about K. Bender Rimbaum.
Okay, Bender Rimbaum is a full-service law firm that specializes in community association law, condominiums, HOAs, cooperatives primarily. We provide day-to-day legal advice and litigation services to our association clients out of our main office in Pompano Beach. I have Palm Beach Gardens, we have Orlando and Tampa. We also have by appointment an office in Miami. So from there, we basically will provide all legal guidance and assistance legally to community associations, be it reviewing documents to determine rights and obligations, pursuing unpaid assessments that are due to the association, contract review and negotiation, enforcement of contracts that are in breach by the other side, construction defects, developer turnover issues, document rewrites. The whole gamut of things that associations deal with are things that we have been doing for continuously since 1992. So it's at 32 years and counting. Our attorneys, of our 21 attorneys, we have 10 who are board certified in community association law. There's maybe 200 in the state of Florida, and we've got 10 of them that work with us. And that makes us specialists in the field.
And basically,
I'm certified in construction defect law.
Okay. You know, I got to tell you, and I thank you for this all the time. Education is so important to your firm. And every month you join us for the 50 minutes. You've got some of your other attorneys in your other markets like Tampa and Orlando, and that also give their time each month. And you just do so many classes and educational classes. You know what? I'd like to start off a little bit different. Let's go over all your classes you have this month. And this way, we can also do it again in the second half of the show.
Well, it's a good idea because there's a lot going on this month.
There is.
Starting off with expos. There are 3 expos coming up in the next couple of weeks. On February 6th in Broward County at the Signature Grand in Davie. We're at booth number 200. And then on February 9th, Friday, in Tampa Bay at the Tampa Convention Center, we're in booth 300. And on February 13th, Tuesday, at the Palm Beach Convention Center, where we are booth 216, we're providing courses at all 3 of those events. We have updating your governing documents from 9:30 to 10:30. And we have the legal update 2024, which are changes from 2023's legislative session from 2:30 to 4:30. So all 3 expos will have classes and we'll have booths. It's free of charge, so certainly anyone can come in and visit with us. We'd be happy to talk with you all more there. Then on Thursday, February 15th, from 2 o'clock to 4:15 on Zoom, we have a Condominium Association Board Member Certification course, which is hosted by GRS Community Management, and Kirsten Hens out of our Tampa office will be providing the class lecture then. And then on Tuesday, February 20th, from 2:30 to 3:15, also via Zoom, we have Navigating the Fair Housing Act, Assistant Animal or Pet. That's still a fairly hot topic throughout the state. Alan Schwartzide from Orlando will be providing the lecture there. On Wednesday, February 21st, from 11:30 to 1 p.m., live at the Weston Community Center, there's a continuing education and lunch networking event. Michael Bender will be on a panel of guest panelists. We're talking about creating harmony, managing conflict management in community associations. This is hosted by Association Community Education, ACE. Then on Wednesday, February 28th, from 3 o'clock to 4 o'clock, we'll be doing a covenant enforcement for community associations via Zoom. Alan Schwartzide will be teaching that event. And since we have an extra day in February, we have something on February the 29th. HOA Board Member Certification from 2 to 4 p.m. Emily Gannon from the Pompano office will be providing that lecture. So busy month in February. Go to our website, kbrlegal.com, and click on the calendar. Pick the event you're interested in to register, to get the Zoom information, or to get the registration information for the live events. And we'll hope to see many of you there.
Wow, what a month. If you have an HOA or condo association question for Robert, you can call us. Now's the best time. We do have one line open at 561-623-9429. That's 561-623-9429. And you can also write on our chat line if you have a question. There's so many things going on. Now we're in February. People still have a lot of questions, Robert.
No, there's always going to be questions, and the legislature's in session, so things can be changing in the next month or so. There are bills pending, but we know the legislative process is not something that is static. Things move around a lot, so it's hard to predict what's ultimately going to come out of it. But they are considering some things up there.
There must be a bill pending about certification. Do you know anything about that?
Certification of board members, or?
Yes, board members.
there is something that's being talked about, but it's premature to really talk too much about it, because while something gets filed for consideration, there will be changes made, lobbying efforts on both sides of the issue that change what's ultimately going to be adopted. So I tend to not get too involved in what might happen, because that can be confusing to a lot of people. They hear it and they think it did happen, but then it ultimately doesn't. So I tend to wait until after the legislature is done and they've actually adopted something before we get too deep in the weeds on it.
You've been doing this for a long time, so I trust you. Let's go to. We're going to go to our text, and I got to tell people we really appreciate the texts that are coming in. Try to make them a question rather than a statement, and you'll have a better chance of getting them on during the show. We're going to start with Guy in Delray Beach. He said, what does a buyer have to do to make sure the seller doesn't owe any assessments?
Well, most associations have a process for when somebody is purchasing, that they submit application and background information about themselves. And then as they get closer to the closing date, whether they have that application process or not, there is a procedure where an inquiry is made of the association for what's called an estoppel certificate, which means there's a list of items that are in the statute that associations are required to answer, plus they include the condition of the assessment account, if anything is owed monetarily. Most of the closings take place through title companies or law firms, professionals who are aware of what they need to do. If there's a transaction going on that doesn't involve those professionals, I don't recommend it, because this is one of the areas that in law school they told us you absolutely should have a lawyer. That, and when you are doing a will. And those are the primary times, at least when I was in law school, they said you should always have an attorney involved. And if you don't have a title company or an attorney assisting, then you make a written inquiry of the association for the estoppel certificate, and they need to be providing that to you in a relatively short period of time.
We got a call right before the show. A lady had purchased a condo, and she found out later there were some fees that the realtor never told her about. What can she do?
Well, again, there's a lot of facts that we need to know before we can say what you can do. Was there a title company involved? Was there title insurance that was provided? Was this information that the seller knew or should have known, and then didn't tell them about? There could be options. Usually the title insurance is the best place to start, because they provide the insurance that everything is as was represented on the documentation at the closing. And if it turns out that it wasn't, that's the best source of recovery. There should always be title insurance when somebody's buying real property in Florida, so that the purchaser isn't going to be stuck, because Florida by itself has always been known as what's called a buyer beware state, where the buyer has to do their due diligence and make sure they leave no stone unturned in finding out information. So that's the best advice on that.
Okay. You know what? I heard there's two companies, and I don't remember the company's homeowners insurance, that are going to be lowering their rates. Have you heard that?
For general liability or windstorm insurance,
Yes.
I heard there was some rumblings to that effect, but I haven't heard much on any kind of a wide scale reduction.
That's
There
all
is
we
always
hear
the
about
hope.
going up.
There's always the hope,
Yes.
and how many people can get in on that? That's another question, because they can only take so many policies before they run out of their limits.
Let's go to Debbie in Pompano, the corporate office. I'm a board member, and we have residents playing pickleball. Robert, we get so many questions about pickleball courts.
#1 sport in America, isn't it?
Playing pickleball in an unused parking lot area. Are we, as board members, liable?
Well, as board members, I would say no, but the association will have potential liability if somebody gets injured in the process of playing on the common areas of the community, which you should have insurance for, and you should check with your insurance agent to make sure that policies in place do provide sufficient protection to the association in the event of an injury on the common areas. If somebody slips and falls or hurts themselves playing pickleball, diving for a shot, associations often are named in lawsuits over things of that nature, and insurance will usually address it. The association may be responsible for a deductible, so long as the association is not actively involved or negligent in what causes the injury. So the fact that they're doing it, it depends on whether or not it's something that's against any published rule or covenant to be doing that in that area, in which case the association should be considering putting a stop to it and making sure that that's not something that happens on an ongoing basis under those circumstances. So there's more information needed before we can give all of the opinion that's needed on that.
Okay. I've been doing the show with you for so long. I recognize names that write into the show, and all of a sudden we've been blasted by all these new names, which is wonderful. Let's go to R.
Happy
Willis
to have them.
first. Yeah, let's go to R. Willis first. Can you read that? Robert just had surgery, eye surgery.
I think you should read it to me.
Okay. Can a condominium board legally restrict the owners from seeing the specific dollar amount of an insurance claim settlement on a financial statement for the association?
Well, all of the association financial records are open to the inspection and copying of all owners upon written request. And so if this information is within the association records, it should be available to them, and the board would not be in a position to keep that from them. There are instances in which the association could be involved in some form of a litigation, and a settlement is reached that's the parties agree would be confidential. When the settlements are confidential by court order, that might contain some restriction on owner access. But even so, I think the statutory obligation of having records open to the inspection of all owners could likely override that type of a confidentiality in a settlement.
Okay. Robert, recently our fining committee agreed to fine an owner. If the owner refuses to pay the fine, what recourse does the association have to collect the fine? Can we collect when the owner sells?
Well, fines sometimes have a good use. Sometimes they're like a paper tiger. Depending on if you're a condominium or an HOA, might affect what your abilities are. In condominiums, a fine is not allowed to ever be an assessment or a lien against the unit. And the statute allows the association can bring an action in small claims court to collect the fine. And in that instance, the association can also recover attorney's fees and costs in bringing the lawsuit. So that's an option to collect on it. Many of our clients will put that on the association or on the individual owner's ledger for their unit. And when they sell, it's just a claim. That's a questionable charge since it's not an assessment against the unit. If there's pushback by the purchaser or the title company, and it causes the sale not to occur, there could be exposure to the association for tortious interference with the contract by making a wrongful claim. But in the vast majority of instances, it's a small dollar amount and the parties simply pay it just to complete the closing process. So that is an option that many associations do follow. In homeowners associations, the statute allows a fine to become an assessment or a lien against the property if it's $1,000 or more for a single violation, and that can happen by $100 a day for 10 days to reach $1,000 on the violation. We couch that with there needs to be language in the declaration as well, the Declaration of Covenants, that identifies the fine to be a lien against the property or an assessment against the property before you could take that route of collection. The problem with fines and just getting the money doesn't necessarily resolve the problem that you find about in the first place. And the primary concern of the board is more about compliance with the violation than adding a little bit of money to the association account. So you typically need to go beyond just a fine to get that compliance.
Okay. We're going to do a follow-up from Wills. In other words, are the financial statements of the condo association completely open to the owners?
They're supposed to be, yes. In fact, the association is supposed to provide an annual financial report every year, either mail it to you or send you notice that it's available for you to get it from them upon request. And many communities will put them on their websites. One of the legislative changes pending is to make websites more required, because right now it's only 150 units or more within the condominium. So they're looking to expand that obligation, but do allow for things to be on the website that will eliminate the need for in-person record inspections, because they'll all be electronically available on the website. So that could have a positive effect if it's adopted.
We are going to take our break now. Steve, hold on there. As soon as we come back from break, we'll get to you. Robert, give everybody the phone number and the website.
You can reach us at 800-974-0680 for all four of the offices, or you can go to kbrlegal.com, or you can write us at info@kbrlegal.com.
We're going to go to break. When we come back, we have more with K. Bender Rimbaum, attorney Robert K. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
This is the Ask the Expert show. I'm your host, Steve-O. We're here with K. Bender Rimbaum. They're a community association law firm here in South Florida, but they also have offices in Tampa, Orlando, and they're also in Palm Beach. This is our number one show between all the shows that we do. We will be getting again to, if you missed the schedule for this month for classes, we'll be getting to that in just a minute. We're going to go to Steve. And if we can get there, we're going to go to Steve. He's got a question. I am so sorry. I just got a new computer, and Robert, they really make them very good nowadays. I'm so sorry. There we go. Okay. Steve says, thoughts on new Estoppel bill, which we spoke about, 5-day turnaround, $250 for a 5-day turnaround, no adjustment for CPL, no payment or Estoppel fees until closing. You said you didn't really want to get into this now because it's so early. Is there anything?
Well, there is a bill that proposes changes to estoppels. There is lobbying going on opposing it that I think has significant points that they're making, and I don't expect it to come through the way that it's originally drafted, if at all. Personally, I don't think it's necessary. I think that there are a couple of people around the state that might not be the most scrupulous that have come to the attention of individual legislators who now write laws to address their individual bad occurrences. I think the vast majority of everybody out there has been in compliance with the last requirements that were put forth. But at this point, we're in a wait and see position. My own personal opinion is I'm opposed to it, but I don't get a vote. I'll deal with it, whatever they do.
You're too cool, Robert. Let's go to Gene and Boynton. Elections ended up with more ballots and voters. So a new election was scheduled, but they never had the additional election. Isn't there a 60-day limit from the date of the election? This is a condo. We never did a new election, and we are now past the 60 days.
Well, if the board held an election that was flawed and didn't hold another election to address that, then the owners should be contacting the Division of Condominiums, because that is an issue that they definitely will jump on quickly to get to the board and make sure that they do hold the election in a timely fashion. The 60 days is not something that's expressed in the statute as to corrective elections. The 60 days is first notice of an election has to go 60 days before it occurs. And there's another 60-day reference in recalling. You can't do a recall within 60 days before or 60 days after an election. So, but relative to a redo of an election that had an error in it, that's not a specific requirement, but it is a requirement that it be done relatively quickly. And so if it's been more than 60 days, the best thing to do would be reach out to the Division of Condominiums, make a complaint there, and let them address it with the board members. And you should find that gets resolved in short order. If you do that and it doesn't happen, then you may need to bring in your own independent attorney to address it in a more formal fashion that way. But get as many owners involved in assisting in the cost of that, because no one owner should have to pay for that themselves.
Okay. I'm going to go to Carrie in Boynton. What can we do when a board picked paint color? We get this all the time. What can we do? Board picked a paint color without residents' votes.
I'm going to have to assume it's a condominium, because that would be the only instance that the law does have such a requirement. But this is something that's going to be document specific to the community on whether or not an owner vote is going to be required for that issue. For condominiums, there's a provision in the statute that says there can be no material alteration or substantial improvement to the common elements except as provided in the governing documents. And if the documents do not contain anything on that, then it by a 75% vote of the owners. The division has decided in its wisdom that a change in paint color on a building is a material alteration. And because of that determination, which was a misconstruing of a case law from the 1970s or early 1980s, condominiums generally have to keep that in mind when they're making a decision to change the paint color. So then you have to look at your declaration of condominium on what it provides for material alterations. Now, sometimes it's just says what the statute says. So it's a material alteration, they need a vote. Sometimes it says if the cost of the alteration exceeds a certain dollar figure or a percentage of the budget, if you have language of that nature, then a change in paint color likely isn't going to reach that threshold, because if you paint it this color or that color, it's going to cost the same or within a small amount difference. So it's likely not going to reach the threshold. It isn't the cost of the painting, it's the cost of the alteration. So you're painting anyway, and that's a maintenance function. So if you're changing the color, that's the alteration. Does it cost you more to paint it this color or that color? And does it reach the threshold of your documents? So that's a consideration. So you really need to look at your documents to see. Now, if the board was required to get a vote of the owners, then your options are to send them a written demand that they did it wrong and that they have to fix it, or go to the Division of Condominiums, and you can put a complaint of that nature in for review by them, or you can consider taking more formal legal action and send a written demand for them to fix it, or you'll bring an action in arbitration with the department within the division, the arbitration section, or a pre-suit mediation before you can take it to court. So those are basically the options on that.
Okay. We're going to go to a longtime listener, Culpepper. What is the approximate cost if the state needs to appoint a receiver as only one board member left?
Well, the state doesn't appoint receivers. The way that works is an owner has to petition the circuit court to appoint a receiver. That means someone has to ask for it. And the cost will be whatever the receiver charges on an hourly basis, what the court will authorize. I'm sure these days you're probably over $300 an hour for the receiver's time, whatever the receiver decides, plus whatever the receiver spends. The receiver can then hire its own attorney and direct all of the operations of the association as the receiver considers appropriate, until such time as there is a board that has at least a minimum number to reach a quorum. So if you have a 5-member board, you have to have at least 3 sitting board members to do any business. If you only have one, that one can appoint additional board members. And that's something that should be done as soon as possible so that the association can properly function.
Going to Aaron in Boca Raton. Is it considered a quorum if you're doing it by email? Our HOA is doing this via emails, approving architectural forms, approving vendors and amounts not done at a statutory board meeting.
And so if I'm understanding the question, it is, can the board take action by email rather than at a meeting? The answer to that is no. The statute expressly provides a board may not vote by email. They can communicate by email, but they can't vote by email. They can talk about issues, they can express opinions, but any formal action, there's only 2 ways it can be done. One is at a meeting that has proper notice and allows owners to attend, or by a written resolution signed by 100% of the board. An email isn't that. So if the board is doing it that way, then they're in violation of the law. So that applies to both HOAs and condominiums.
Here's one I might want to do for an HOA and condominium. This is Ronald in Lake Worth. He is an HOA. He's a sitting board member. Can a recall be done to get rid of a board member?
Well, absolutely. That's one of the ways that a board member can be removed from serving on the board is by a recall by a sufficient number of owners within the community. Most of the recalls we see are done by what's called written agreement, which is using a form that you can get on the Department of Business and Professional Regulation website. And you just fill out all the information on the form, who the director is that's going to be recalled. If it's less than a quorum of the board that's being recalled, then you just need yes or no to recall the person. You don't need a replacement director. The board would fill that vacancy. If it's more than a quorum of the board, then you need to include replacement directors on the form. There also needs to be a unit owner representative identified on the form. And so they collect a majority plus of the owners signing on these forms and then deliver it to the association either by certified mail or by a process server. And that starts the clock for the board to determine whether or not it's valid recall and whether or not that person is off the board. A board member can be a participant in removing another board member.
Okay. Let's go over the schedule for February.
Okay. So coming up in the near term, we have 3 expos throughout the state. The first is February the 6th in Broward County at the Signature Grand in Davie. We're booth 200. And then on Friday, February 9th in Tampa Bay at the Tampa Convention Center, we're booth 300. And then on Tuesday, February 13th in Palm Beach at the Palm Beach Convention Center, we're booth number 216. At all 3 of these events, we'll be teaching 2 courses, one in the morning, updating your governing documents. That'll be from 9:30 to 10:30. And the second is a legal update 2024, which involves the changes to the legislation in 2023. That'll be from 2:30 to 4:30. The instructor will be from the offices in those areas, and I don't have the specific instructors at the moment. Then on Thursday, February 15th, from 2 to 4:15, there's a Condominium Association Board Members Certification class. Kirsten Hens from Tampa will provide the information. This is via Zoom. And it's hosted by GRS Community Management. On Tuesday, February 20th, 2 to 3:15 on Zoom, we have Managing the Fair Housing Act, Assistant Animal or Pet. Alan Schwartzite from our Orlando office will be providing information in that particular case. Wednesday, February 21, from 11:30 to 1 p.m., there's a live event at the Weston Community Center. It's a lunch and networking event that will also have a panel discussion. Michael Bender from our Pompano office will be one of the panel members. And they're going to be talking about creating harmony, managing conflict management in community associations. And that's hosted by ACE, the Association Community Education. Wednesday, February 28th, from 3 to 4 p.m., we have a Zoom class. Alan Schwartzite will be doing covenant enforcement in community associations. And on Thursday, February 29th, since we have one more day in February, from 2 to 4, we have Emily Gannon will be doing an HOA board member certification. Now, many of these classes have continuing education units for CAMs, so go to the website at kbrlegal.com, click on the calendar, identify which one you want to participate in, and get the information you need so that you can be registered, and you can see which ones have how many credits. kbrlegal.com, or you can write us info@kbrlegal.com, or call 800-974-0680.
We just got a first time question of this topic. They want to know if you were invited to come speak to their community. Who do you normally speak with? Is it the president or all the board members?
It will vary. If it's an invitation to be considered as legal representative for the association, it's typically the entire board or a committee of the board. Sometimes the president will reach out, or a committee of representatives. There's no hard or fast rule on that. Once retained, we recommend that the association identify a designated individual who is the contact person to the law firm, so that they can manage communications as well as the costs that the association will incur in getting legal advice. If everybody has the opportunity to reach the lawyer and ask questions, sometimes you can get conflicting questions that aren't exactly what is intended. And you'll also be getting charges for legal services for going over the same things, or different perspectives of the same thing. So it's generally more efficient and I guess cleaner to have a specific individual who's tasked with communicating back and forth. Usually it's the president. We also typically see the treasurer identified when there's collection issues that are going on. Sometimes it's a whole board. It's really a community decision.
We're going to go to Rhonda and Delray. Are unit owners allowed to give proof of a support dog without the medical reason?
Are unit owners allowed to give? Is that the question?
To get proof.
Get proof.
Get proof.
So you think, can the unit owners find out about an emotional support animal that's on the premises?
That's what it sounds like.
That documentation? That documentation is not going to be available to inspection of other unit owners. That's generally medical information on the resident, and that's something that would not be open to the inspection of another owner. The board will do its due diligence and should be assuring the owners that they've obtain the necessary qualification and supporting documentation for an emotional support animal that's going to reside in a community that's otherwise no pets.
May an owner be allowed to set up a Facebook account for owners to look at document productions, to see the facts for themselves, and to make a decision?
Well, whether they're allowed or not is a subjective thing. Sometimes the boards are all in favor of it. Sometimes they're adamantly opposed. So long as whatever the owner does is clear that it's not affiliated with the association on the website itself, or the Facebook page, whatever it is, has to have clear identification that it's not an official page of the association, that opinions there are those of whoever's page it is or whoever's participating in the page, and otherwise disassociates itself from being an official association location, then the association would be sufficiently protected and in all likelihood have no issue with it.
Okay, let's go to Catherine in Aventura. I love your show. I just became a viewer 3 months ago. Now I would
Welcome.
not miss the show.
Mm-hmm.
We don't get a lot of people writing in from Aventura, but anyway, she
Sometimes.
wants to know, the board wants to increase up to 100% of our condo monthly fees, claiming reserves. Language is not clear. They want to explain on the day of voting. How can we stop that from being voted on?
You basically cannot stop that. It's a board decision. We know that reserves are a hot topic these days, and given the requirements that are just around the corner, many condominiums, particularly high-rises that are not far from the ocean, are finding that their planning has been deficient and that they have significant amount of reserves that they have to make up. And the board's going to have to address that. Some of them can be waivable during this year, but a number of them, unless the legislature makes changes this year, won't be in 2025. But it's always been a board decision as to whether to present the waiver or reduction of reserves in the first place. The statute requires that budgets adopted by condominium association boards contain full reserves for all of the items that the statute says they have to reserve. And only if the board chooses to present something less for a vote of the owners would that happen. So here the board, I'm not sure what they're voting on in this instance, but the timing of it is at the discretion of the board. Is it the right decision? Maybe not. Is it politically better to give more time for owners to understand everything? Typically, yes. But ultimately, it's a business decision for the board to make as to the timing of these things, and owners have very little they can do to stop it, short of changing who's on the board.
I'm going to get one more question in for tonight. It's, I guess you answered one of their questions. Thank you. We had a budget meeting, only the condo president still on the board, no others, and tried to approve budget unilaterally. Is the association in legal jeopardy from this action?
If I understand the facts, there's only one board member left, the president,
Yep,
and,
the president.
and acting unilaterally. Well, that would not be a valid action of the association because it takes at least a quorum of the board to take any action at all. The only thing a surviving board member can do when everyone else has resigned or left the board would be to appoint other directors to get to a minimum quorum. We can appoint one, two, or however many they need. Can appoint one, and then the two of them can appoint a third, or one person can appoint several at once, but no action taken by the individual is supportable under the law because there hasn't been a sufficient quorum of the board to take the action. So they need to fix that, particularly when it comes to assessments, because if somebody refuses to pay and the association tries to lien and foreclose, those people have a valid defense, And in that instance, the association will not be able to collect what they think is due it, and will have to pay the other side's attorney's fees as well as its own. So that's going to put it in a very difficult financial position. So we don't recommend relying on that.
Well, that's going to do it for us this evening. As always, Robert, great information. You'll be back with us again next month. Give everybody, Robert's with us the first Thursday of the month at 5 o'clock. Every month, be with us next month. Give everybody the main number and the website again, Robert.
Sure. Main number is 800-974-0680. Website is kbrlegal.com. There's a contact box on the first page that you fill out, and someone will get back to you on that, or write to us at info@kbrlegal.com and let us know what it is you're looking for, and we'll get back to you.
You're the best. Get better. We'll
Thank
see
you
next month.
Have a good one.
Thanks, Robert. That's Robert, Attorney Robert K. Ask the Experts. Always does such a great show. He's been with us for right at 10 years now. Long time. Anyway, we got to go. Got to get out of here. We will be back with you again next Thursday with more Ask the Experts. Have a good weekend, everybody. God bless.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.